Hello, I'm Adam Kielich with the Kielich Law Firm, and this short video is about waivers of service. A waiver of service is a document used in litigation in which a respondent or defendant to the lawsuit agrees that they do not need to be served by a process server. Under both the federal and state constitutions, a party has a right to be served notice with any lawsuits or other claims brought against them in a court of law. In order to be noticed with those claims, a party needs to be served with two documents. One is a copy of the petition or other pleadings filed. The other document is what's called a citation, and this is a document that notifies the party that they've been sued and that they have a certain period of time to file a response and where that response needs to be filed. The combination of these two documents together is what's called process, and that's what a process server would serve. A respondent or defendant, depending upon the type of lawsuit, can agree to waive service through a document, through this waiver of service, in which they sign before a notary stating that they waive their right to be served with process. In addition, the waiver can also waive future notice of subsequent hearings or other activity in the case. It can give certain types of testimony. It can also waive rights to contested hearings or to give testimony in a trial or other hearing before a judge makes a ruling in the case. The most common ways that waivers are used is in a divorce proceeding, and typically in uncontested divorces. And the reason why parties use waivers of service, really there's a couple of reasons. One, it saves money. A process server and having citation generated usually runs between $75 to $100. If the parties agree on the divorce, there's really no reason to waste money just to have those documents delivered. It can also save some time in getting the process started and getting the parties together to finalize the divorce and come to any agreement necessary to get that done. Outside of uncontested divorces, waivers of service are sometimes used in other cases where both parties know that the lawsuit is coming. Maybe they're going to cross-file against each other, or they're specifically filing to have the court resolve an issue, and they're not necessarily antagonistic. There's just a disagreement about how to resolve an issue. That could be like contract-type cases. In federal courts, waivers of service are often used for the same purposes to avoid the expense of a process server. And there are some special federal rules that apply with how waivers of service are used and whether parties must or should grant the waiver of service. For state courts, though, at least in Texas, there's no requirement that a party sign a waiver of service. There's no penalty for a party not signing a waiver of service. So it really depends for the defendant or respondent in a family law issue whether it makes sense, whether the party should waive service, and what all other kind of waivers are within that document. But a waiver of service will not be accepted by any court in Texas if it's not notarized. It's just not enough to show up to court with a document with somebody's signature or supposed signature. Usually, waivers of service are drafted by attorneys and sent out to pro se parties. But of course, two pro se parties could send waivers to each other or attorneys. Doesn't really matter. But that's pretty much it. That's all a waiver of service is. A lot of times people get them in divorces when they're pro se parties. Don't really have a good sense of what this document is, what kind of rights they're giving away. So it is important to read what's actually in that waiver of service and make sure that what's being waived is not more or less than what the party needs or desires to make sure that their rights are protected.